The quote sets out that a man is not entitled to rape his wife, and every woman should have control over her body. Unfortunately, this is not Malaysian law's position. In the early 2000s, it was already reported that 52% of Malaysian women were experiencing marital rape. With such an alarming number, evident is the need to criminalize marital rape. Malaysian law does not criminalize marital rape. In fact, it sets out an exception that sexual intercourse between a wife and a husband without the wife's consent is not considered rape. By the literal words of this section, it sets out that the rights and protection of a married woman, which has been sexually assaulted, is not prioritized. As a woman is not deemed to be the husband's wife if she is in the midst of a judicial separation, has an injunction or restraining order against him, or in the midst of her IDA period after separation. To be asked is whether are there any initiatives taken by Parliament to criminalize marital rape. In 2018, our Deputy Minister Dan commented that it was not time to criminalize marital rape, and Section 375A of the Penal Code was enough to protect the woman. Section 375A of the Penal Code reads out that a man which causes fear, death or hurt upon his wife to have sexual intercourse will face a maximum imprisonment of 5 years. Maria Chin Abdullah, opposition leader's view, is that marital rape cannot simply not be a crime unless a husband has caused injury to the wife during sexual intercourse. Marital rape should be criminalized for the following reasons. Firstly, Section 375A is not sufficient to protect married women from marital rape. This is because it does not mention rape itself. It mentions sexual intercourse, but however, this is only applicable when the husband caused hurt, fear or death upon his wife. It does not cover areas of other areas which the husband may be acting on, such as intoxication and the other ways of coercion. Additionally, there's a 15 years difference between the maximum sentencing years between someone who conducts rape under Section 375 and Section 375A. Therefore, it sets out that a woman who has given all her love and affection towards her husband, which has now transformed to inflict abuse and force towards her, will face a much lower sentencing rather than an unknown person who has raped her. This sets out that a woman loses all her rights upon marriage. Secondly, Section 2 of the Domestic Violence Act 1999 covers the word sexual abuse. However, I would have to agree with Maria Chin Abdullah that under Domestic Violence Act, the court is only allowed to give a protection order. Additionally, Section 3 of the Domestic Violence Act sets out that it has to be read together with the Penal Code. Thirdly, Article 5 and Article 8 of the Federal Constitution lay out right to liberty and all persons are equal before the law. The case of Siva Rasa Rahsia and Badan Kebuan Malaysia sets out that Parliament is prohibited from producing law of unfair discrimination. Therefore, there is no justification to the discriminatory provision of Section 375A, which prejudices the right and protection over married women and favour married men over unmarried men. This is unfair, unjust and arbitrary, contrary to the Federal Constitution. Fourthly, Malaysia as a state is acting contrary to their international obligations. Under Article 5 of CEDAW, which has been ratified in Malaysia, it sets out that Malaysia has to modify cultural patterns of men and women. However, Malaysia has not even criminalized marital rape, let alone contradictions of the law. Marital rape should be criminalized because of the impact it leaves on the woman. Based on a research conducted by Diana Russell, when you are raped by a stranger, you live with a frightening memory. When you are raped by your husband, you live with your rapist. English law has shifted to recognize marital rape. In the case of R&R, Lord Lane set out that a rapist is a rapist, despite the relationship he had with the victim. English law took the position that both men and women are equal in position and a woman does not lose her rights upon marriage. In the United States, in the case of People and Liberta, the statute which protected married men from rape was held unconstitutional as it went against the Equal Protection Clause in their constitution. As for Asian countries, marital rape is illegal in Cambodia, Thailand, Tunisia and Philippines. Nevertheless, there has been no significant movement by Malaysian judicial body or parliament in criminalizing marital rape. The simplest reform given by Maria Chin Abdullah herself is just to remove the exception under Section 375. However, this may contradict some Sharia principles such as your woman is your tilt and tilt as you like, and biblical notions that a man and woman should become one after marriage. To conclude, I submit that this reform has to be carried out despite the religious contradictions, as it does not set out that a man and woman cannot have sexual intercourse. It just sets out that a man and woman have to consent to the sexual intercourse. Every man and woman should have the rights to their bodily parts. I will now pass on to Rochi to address the gender-specific law.
Other than the issue of marital rape mentioned by Abigail, there are also other general issues regarding the law of rape. The first area of the law of rape in Malaysia that has to be amended is that it is gender specific. As seen in Section 375 of Penal Code, the perpetrator was stated clearly that it must be a man and the victim must be a woman. According to Corbett and Corbett, the general rule is that a person's gender is what a person was at his or her birth. Therefore, an issue arises here is that what if a person had transferred his gender through gender reassignment surgery? According to an article named Proposed Amendments to the Law of Rape in Malaysia, the individual who undergoes this kind of surgery has to make a declaration under Specific Relief Act 1950 in order to change his or her gender from what it was during the birth. Besides, requirements such as changing of identification cards have to be made too in order to comply with such changes. Without these changes, the person will still be regarded as the gender during his or her birth time and cannot reflect their gender after the surgery. As seen in JG and Pengarah Jabatan Pendaftaran Negara, although the plaintiff in this case is able to change his identical number in the end, this is still not an easy task. It is complicated and burdensome. This can be seen through the facts that the plaintiff has to come up with several professional consultants in order to prove that she is now a complete female, not only from a physical perspective, but also from the mental and psychological perspective. Only then, the general rule that the advice of a medical profession to assess and determine the sex of a person can now be satisfied. All these requirements indicates that it is hard to change the gender in Malaysia, and without changing it, the transgender will never have a chance to sue or be sued in a rape case. In such cases, the accused will have the chance to be scot-free from the charge of rape just because the accused cannot be declared as a male or the victim cannot be declared as a female by the prosecution. Other than the issue of transgender, there is also an issue of male rape in Malaysia. The possibility of a man being raped by another individual cannot be denied, and the rights of being protected under Penal Code should be entitled. In journal article Male Rape, the Emergence of a Social and Legal Issues, Noreen Abdullah Khan cleared the myth by stating that all men are potential rape victims. This is further supported by the statistics provided by a report released by the Ministry of Justice in UK, which stated that there is approximately 12,000 males being raped in the previous year. Despite all the proofs mentioned just now, in Malaysia, a man still cannot be a victim of rape under Section 375 of Penal Code, and if a man is being raped, the accused can only be charged under 377 of Penal Code, and under this section, the element of consent is not being mentioned, which is discriminative and insensitive. Therefore, the law of rape in Malaysia being gender-specific should definitely be amended to provide more justice. Next, I will be discussing about the reform recommended for this issue. Compared to the other countries such as law of rape in UK, it is not gender-specific. In Section 1 of Sexual Offences Act 2003, the wording had been changed from a man and woman to a person A and person B, so that the perpetrator can now be both man or woman. With this modification, both the problems mentioned above can be solved. Regardless if the accused and the victim are transgender, or the victim is a man, as long as the victim's vagina, anus, or mouth is penetrated by a penis, the actor's risk of rape is being satisfied. Other than changing the wording of the provisions, the Parliament of Malaysia may also come up with a new act or adding new section under Penal Code, specifying that any sexual act which tends to cause harm to the transgender victim, such as rape and sexual harassment, should be liable and punished under such provisions. This can be seen in the Transgender Person Protection of Rights Act 2019 under Chapter 8, Section 18, Subsection D, even though this provision is being criticized for neglecting and discriminating the transgender, as accused who commit such offense can only be punished for maximum 2 years of imprisonment and fine. Nevertheless, we can still use this legislation as reference but improvise on certain parts such as increasing the imprisonment period. By adopting this, we can solve the problem of a transgender person not being protected under Penal Code. That's all from me. Moving on, I will pass on to Teck Hyun, who will discuss about the issue of replacing the wording sexual intercourse with sexual penetration.
Moving on, it is submitted that the term sexual intercourse should be replaced by sexual penetration as it provides more certainty, clarity, and at the same time, widen the scope of the offence of rape under Section 375. This is due to the fact that there is no definition provided by the Penal Code for the term sexual intercourse. And according to the Oxford Dictionary, sexual intercourse means the physical activity of sex, usually describing the act of a man putting his penis inside a woman's vagina. Therefore, non-penal penetration caused by foreign objects or other bodily parts is not regarded as rape as defined under Section 375 of the Penal Code, but constitutes other criminal offences under the Penal Code depending on the means of penetration. Although Section 375 of the Penal Code does not include non-penetration as rape, there are other plenty of provisions under the Penal Code that could be used by the police enforcement or the public prosecutor to combat such acts. For example, Section 326, Section 354, and Section 377CA under the Penal Code are possible provisions that are available to protect the victim from non-penal penetration. However, each provision has its own flaws. For cases of forcible penetration by object, Section 326 is a possible provision to apply. However, a person could only be charged under Section 326 if the injury suffered by the victims fall within the meaning of grievous hurt as defined under Section 320. Besides, the weapon used has to be dangerous and likely to cause death. Hence, it is very difficult to fulfill the elements under Section 326 as the standard is too high to achieve. Alternatively, Section 377CA is also another provision that could be applied in cases involving penetration by foreign objects. However, this provision is overlooked by the law enforcement and the Attorney General, as it has been discovered that almost no cases have been brought to the court under this provision. Furthermore, for non-penetration caused by other bodily parts, it should not continue to be governed by Section 354, as the punishment provided under it fails to reflect the severity of such act as seen in the case of Bunya Anak Jalong and public prosecutor. This is because it would be ironic for the offender who impregnated the victim to receive a lighter punishment just because the means used is not a penis. This view is supported by the judgment given in this case, as the court refused to convict the defendant on lesser charges because it did not want to condone such lesser charges as sufficient punishment. Moreover, it is rather difficult to charge the offender under Section 354, as it has to be proven that the physical injury must occur and eyewitnesses are required in order to find the offender guilty under Section 354. However, there are not many cases where the offender are charged successfully under this provision, as some of the medical reports show that the hymen of the victim is still intact, and the vaginal tissue have not been damaged, and therefore no physical injury could have been said to have occurred. Hence, it is submitted that the introduction of the term sexual penetration to replace sexual intercourse is the most effective way to protect the victims from non-penal penetration, as it is a catch-all term which includes non-penal penetration by all kinds of different means. With that being said, all kinds of sexual penetration, including non-penal penetration, would then be considered rape under Section 375. This is beneficial as the law needs to reflect the severity of the offences, and separating the offences into different provisions with different punishments may appear that the law views a particular crime less or more seriously as compared to the other. Next, I'll pass it on to Amelia to discuss about the confusing ages under the Penal Code.
The next issue that demands reconsideration is the issue of confusing ages for consent when it comes to statutory rape. Statutory rape is under Section 375, paragraph G of the Penal Code, and it's basically when a man has sexual intercourse with a woman with or without her consent when she's under 16 years old. These cases are examples of statutory rape where the accused was convicted even though the victim consented. Here, consent is immaterial, and as the law views that a woman under 16 does not have the capacity to validly consent to sexual intercourse. However, In the Sexual Offences Against Children Act 2017, Section 2 provides that a child is under 18 years old. Section 14 then provides that any person who for sexual purposes touches any part of the body of a child commits an offence. Thus, this includes sexual intercourse in this provision, as there would be touching for sexual purposes in the act of sex. Hence, Lai in his article gave the example that it doesn't make sense that a 17-year-old girl can consent to sexual intercourse with a man as she is above 16 years old, but that same girl cannot consent to sexual assault under Section 14 of the Sexual Offences Against Children Act 2017 because she is under 18 years old. Essentially, the law allows the man to have sexual intercourse with a 17-year-old girl, but does not allow him to touch any part of her body. Therefore, the age of consent needs to be standardized, especially between the Penal Code and the Sexual Offences Against Children Act. Furthermore, in Section 375, it states that rape is committed when a man has sex with a woman with or without her consent when she's under 16 years old. Now, this indicates that legislators hold fast to the belief that women below 16 years old does not have the capacity to consent. And this flows from the paternalistic nature of the law, which seeks to protect and prevent harm from occurring, as Richard Orr argues in his journal article. Yet, in Section 376, it provides that the higher punishment for rape, which is minimum 10 years of imprisonment, only applies if the man rapes without the 16-year-old consent. If there was consent, then the accused would obtain the lesser punishment, which is a minimum of 5 years. So, because of this acknowledgement of the role that consent plays in sentencing, it can be inferred that legislators do agree then that 16 years old have the capacity to consent. The wording of Section 376 thus requires clarification as to the definition of consent to show uniformity regarding the consent of a minor's consent. Additionally, it was found that there exists a legal loophole in which those alleged of statutory rape can utilize to escape conviction, and that is marrying their underage victim. Now, this issue is predominantly in the Muslim community where Islamic State laws have exceptions that can be taken advantage of. Hence, I will be focusing on the Muslim demographic. Now, Malaysia is a dual-track legal system which consists of both the civil courts operating parallel with the Islamic Sharia courts. Thus, the legal age of marriage in Islamic law is 16 for the female and 18 for the male. But the girl can still be married at a young age if the Sharia court grants permission. And this is in Section 8 of the Islamic Family Law Act 1984. Dr. Muzaffar opines in his article that this is a major issue as the accused can simply marry the underage victim under Section 8 of this act to escape conviction. Hence, if the marriage was approved, the accused will avoid all criminal charges against him for statutory rape. And there is a high chance for this type of underage marriage to be approved. According to JKSM data, the approval rate in 2015 was 81%. Thus, legal reforms are very much needed to plug this loophole. Hence, Dr. Amikai suggests in an article that the Sharia Judicial Department of Malaysia should develop a stricter standard operating procedure for marriage applications involving minors, and this would be then used as a benchmark for Muslim cases nationwide to ensure uniformity across states and that child marriages to their rapists won't be easily approved. By implementing these attainable reforms, minors will be better protected and perpetrators will face justice.
Moving on from Amelia's discussion about the age of consent in the law of rape, another area in the law of rape in Malaysia that needs to be amended is the repetitive provisions under Section 375. Under Section 375B, the accused will be charged for rape if sexual intercourse with a woman is done without the woman's consent. But even if there is consent, there are also circumstances which could still constitute rape. And these circumstances are provided in subsections C to G of Section 375. It is important to first note that the definition for consent is not stated in the Penal Code. What is provided in the Penal Code are circumstances where consent will not be considered to be valid. That is covered under Section 90. First, take a look at Section 90 subsection A and Section 375 subsection C. Essentially, the situation provided for under both provisions are almost identical. And following the description under Section 90, the situation of Section 375C should be considered as no valid consent. The issue here is that number 1, Section 375C is a repetition of what is already stated in Section 90A of the Penal Code. Number 2, it may cause confusion as to why Section 375C falls under a situation with consent when it is clear that there is no valid consent in the same situation under Section 90A. Since there is no valid consent, it should fall under Section 375B, sexual intercourse without consent. Moving on, Section 375 subsection D is also a repetitive provision, because this situation still falls under the scope of Section 90A. That is, a misconception of fact and the person doing the act knows or has reason to believe the same. Hence, applying the same rationale explained earlier, this provision should also be removed and fall under Section 375B, whereby there is no consent. Next, there is also a repetition between Section 375E and Section 90B of the Penal Code. Both provisions focus on the same situation, which is unable to understand the nature and consequences of that to which she or he gives consent. Again, since the contents of both provisions are highly similar, there is unnecessary repetition and this causes confusion. Furthermore, Section 90B is more detailed compared to Section 375E because Section 90B included that the situation must stem from unsoundness of mind or intoxication. Besides that, the necessity of Section 375A is also questioned. Section 375A provides that sexual intercourse against the woman's will is considered rape. Meanwhile, Section 375B states that sexual intercourse without the consent of the woman is considered rape. The question is, if the sexual intercourse is against the woman's will she then still be said to have consented to it? According to Arthur Lai in his work Proposed Amendments to the Law of Rape in Malaysia, the answer should be no. In this journal article, it was submitted that if the sexual intercourse is not something that she is willing to engage in, the law should view that she is not consenting to the same. Therefore, Section 375A is also unnecessary. For greater clarity on the law of rape, to reduce repetition and confusion, an amendment to remove subsections A, C, D, E, and F should be made. As pointed out earlier, there's also no definition for consent provided under the Penal Code. Therefore, another suggested amendment, following Arthur Lai's journal article, is to include a definition for consent or an explanation on what amounts to a valid consent. For example, reference can be made to Section 74 of the United Kingdom's Sexual Offences Act 2003. With a properly defined consent, the law does not have to lay out a series of hypothetical situations to show whether or not there was consent. Instead, this one definition will remain relevant and applicable to different situations. With that, we have come to an end to the group presentation. Thank you.